Well, it's a pleasure to introduce some key members of the legal team for Lloyds Action Now. I have with me Mr. Johan de Toy, Senior Counsel, Mr. Rye, Solicitor, Winkworth Sherwood, and Professor Kuhner of the University of Trier. Starting with you, Mr. Rye, you are a solicitor and partner at the established law firm Winkworth Sherwood, which is based in the City of London. Can you just explain a little bit about your background and your involvement in the case?
Sure. I'm head of litigation at Winkworth Sherwood. I've been practicing for 15 years now. I've got banking litigation experience. I've been approached by Lloyds Action Now to act on behalf of a number of aggrieved shareholders, and in particular a number of test claims. My experience in this comes from one particular case that I've been involved in, a class action which involved several tens of millions of pounds against a major retail bank. The hallmarks are very similar to this, and obviously that information's got out into the marketplace, and hence why I'm here.
Thank you. And Mr. de Toy, you're Senior Counsel at Selborne Chambers.
Yes, that's right.
Could you explain how your role fits in with what Mr. Rye's just said?
I'm retained by Lloyds Action Now Association to advise them on bases on which we could proceed in this matter, causes of action, and I've advised them that there were at least two main causes of action available to them. The one based on misrepresentation, not only by directors of Lloyds TSB Bank, but also by Her Majesty's Treasury. And the second main thread of the cause of action is one based on a violation of the European human rights law.
Thank you. And Professor Kuhner, that's what you're here with us to talk about today. Right. Now, you're here with us from Germany, the University of Trier, but of course you hold seats and doctorates from elsewhere, that's right?
Yes, from a number of international universities worldwide. Just to mention two of them, I've been teaching here at Westminster University for more than 30 years, and I've been teaching at Robert Schumann University in Strasbourg. And my major is international criminal law and human rights, and I have been representing a number of applicants in Strasbourg at the European Court of Human Rights, as well as states who have tried to defend themselves against these applications. So I know both sides of what is going on in Strasbourg.
Fantastic. And can you explain the scope of your input into the action?
Right. We have from the very beginning on to consider the breach of Article 1 of the first protocol of the European Convention of Human Rights, because all arguments which we would have to present to Strasbourg have to be mentioned already at the domestic level. This is why we have to be very careful and very cautious to implement all these arguments already here, although we can only turn to Strasbourg after we have exhausted the national remedies.
Right, and can you explain how the issues raised in the cause of action relate to the protocol?
Well, this Article 1 of Protocol number 1 is guaranteeing the free enjoyment of possessions, which means that you are free to use your own assets, whatever they may be, and the state has got no right to interfere with that without having a legal basis for that. And in this case, it seems to be evident that by the intervention of the state through Her Majesty's Treasury, a number of people, shareholders in this case, have been damaged and have suffered a reduction of their assets of a high amount of money, and this amounts to a violation of the right to free possession and enjoyment of possession. This is why this article has been violated, and if the domestic level, the courts at the domestic level, don't consider this, we can go, and we have to go to Strasbourg, and then Strasbourg has got the power to correct the English courts or even correct the English legislator, which is possible under the convention in case it is necessary.
Thank you. And Mr. Dutoy, can you explain how the course of action will be developed?
Well, this claim, of course, lies against government itself. So the human rights action will coincide with the misrepresentation action as against Her Majesty's Treasury. And I just want to emphasize the one important point is that the groundwork must be done now. It doesn't help to do a half-hearted case now, not aimed at the human rights course of action, and then later try to expand on that. It must be done now, and they will run concurrently in one case in all probability, and that is the starting point for us.
Thank you. And Mr. Rye, do the proceedings have to be commenced in England?
Yes, they do. We've, just so that you have some background, we've actually issued a letter of claim. We've asked the other side, i.e. the Treasury and the directors of Lloyds and the ex-chairman, to consider an ADR solution, which is an alternative dispute resolution solution. If they ignore that, then the next course of action is to issue proceedings in the High Court, but that doesn't prevent us from going to Strasbourg after.
So can you just summarise what we hope to achieve by going down this route?
We hope to try and get some form of consensual agreement approach with the government and with the directors to see if some common sense can be brought into the equation and these people can be compensated. Everyone knows that what's happened is wrong, and with the new government in, hopefully they can make amends.
Let's hope so. Thank you.